Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Greetings, good people. As of the time of this recording, the Laken Riley Act has made its way past the first procedural hurdle in the Senate and seems to be barreling towards a vote with significant bipartisan support. It has done so despite not containing any of the immigration protections long fought for by Capitol Hill Democrats, and despite, among many other things, permitting indefinite detention without even the possibility of a bond hearing for people who are merely arrested of certain offenses. No conviction required, nor need the arrest be violent. The act as currently written will also essentially permit states that want to detain as many non-citizens as possible, always and without discretion, to sue the federal government in the future for this purpose, despite not providing similar causes of action and standing for states that believe that the federal government is violating U.S. law for other, perhaps more humane, reasons. If you do not want this bill to pass, now is the time to call your senators in a slight panic, urge your advocacy groups to go all in on the fight, and well, just generally, do what you can. We're just beginning, folks. Perhaps recognizing the stress of all of this, the circuit's provided only one wise analysis for me to review this week. But oh my, is it an interesting and important one. We'll get to that right after this. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And well, I recently had the opportunity to talk to the folks at Serenade about their case management system, e-immigration. They've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI Workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. Our first and only case is Akinsanya v. Garland, published by the First Circuit on January 10th, 2025. This case is about deferral under the Convention Against Torture, the United Nations Convention Against Torture, the last hope of someone who's done something bad. Here, Mr. Akinsanya is from Nigeria and asserts a fear of the terrorist entity Boko Haram. Why only cat deferral? Because about 5 years after overstaying his visa, Mr. Akinsanya was convicted of conspiracy to commit wire fraud under 18 U.S.C. Section 1343 and Section 1349, and aggravated identity theft under 18 U.S.C. Section 1028 AA1 and 2 in the United States District Court for the Southern District of Texas. He received an 87-month prison sentence. It was all deemed a per se aggravated felony and a particularly serious crime that barred Mr. Akinsanya from asylum and withholding of removal, given the prison sentence of over 5 years. So there's that. Got it out of the way. The visa he overstayed, by the way, was a B1 visa to attend a police conference. Interesting. His claim is quite the claim. Before entering the United States, Mr. Akinsanya served in the Special Anti-Robbery Squad, known as SARS, of the Nigerian police force. In 2013, the Nigerian government investigated the SARS unit for a host of allegations, including corruption, nepotism, abuse of power, and providing material support to Boko Haram. Mr. Akinsanya cooperated in that investigation, which culminated in the arrest of several officers, not him, and included a deputy commissioner. After the investigation, the government reassigned Mr. Akinsanya to a different police unit in the northern region of Nigeria. And of course, that's where Boko Haram operates. This new unit was focused on combating kidnapping and human trafficking by Boko Haram. Quote, meanwhile, Mr. Akinsanya began receiving anonymous telephone calls and texts that caused him concern for his safety, end quote. While in the United States for that police officer conference, or at least while still in status, Mr. Akinsanya, quote, learned that one or more people had broken into his house. They took his laptop, vandalized a file cabinet, removed a confidential file identifying Boko Haram informants, and left a threatening letter. Mr. Akinsanya also learned that Boko Haram had attacked his new division and caused the deaths of 8 officers, including 2 who had been reassigned with him, end quote. That's why he decided to remain in the United States. Over the next few years, several SARS unit members died under, quote, suspicious circumstances, end quote. And Mr. Akinsanya's own family in Nigeria were attacked by individuals who were looking for him. Then his ex-wife and daughters were beaten and hospitalized by people looking for Mr. Akinsanya. That's early 2021. Quote, the police investigated the incident. Mr. Akinsanya believes the attackers were associated with Boko Haram, end quote. A similar thing happened to his sister later that year, where the attackers threatened to kill Mr. Akinsanya. The sister was shot and hospitalized. She, the sister, believes that the attackers were Boko Haram affiliated or members because of their dialect. Police demanded bribes to investigate. The IJ here held several hearings on the matter, where Mr. Akinsanya, his friend, the sister, and an expert witness all testified. Big-time case. The IJ denied cat deferral through a written decision that qualified the expert as well, an expert, and found everyone credible. The IJ just didn't believe that the Nigerian government or a public official working for the Nigerian government would consent, acquiesce, or turn a blind eye to the torture that Mr. Akinsanya feared from Boko Haram. A cat requirement, of course, when the feared torturer is not a country's government. After all, reasoned the IJ, Nigeria has designated Boko Haram a terrorist entity, and it's been fighting them for, ever. Plus, the police responded to the 2013 break-in to his home and the 2021 attacks on his sister and ex-wife, apparently. After all, reasoned the IJ, quote, general ineffectiveness in preventing widespread violence and crime affecting the population at large, end quote, doesn't cut it. The BIA affirmed. The First Circuit did not. In the First Circuit, the government acquiescence and consent analysis for cat protection is a two-pronged analysis. Quote, an applicant must first demonstrate the likelihood of a foreign government's awareness of the torture and then show a likely breach of the government's duty to intervene to prevent the torture. End quote. What does that all mean? Well, in making this analysis, First Circuit case law provides for several considerations and pseudo-sub-requirements bulleted in this decision by the court. The agency should, for example, quote, identify the nature of the legal duty that the government owes under the circumstances, and then consider whether the steps, if any, taken by the government officials satisfy that duty, end quote. The agency shouldn't just rely on any record evidence that a government will protect or could protect or has taken efforts against private torturers. A breach of the duty to intervene can still lie when a government takes some efforts. Not only that, this, quote, duty to intervene inquiry is especially important where the record suggests that the government's steps have been inadequate and ineffectual, end quote. In such cases, quote, the agency must explain why the government's steps, though inadequate or ineffectual, nevertheless satisfy its duty to intervene, end quote. And of course, the agency must carefully weigh all evidence. I don't know, seems like a literal legal section for every cat brief filed before UIR in the First Circuit. The court deemed the agency's analysis here inadequate. And I don't know also, reading between the lines, the First Circuit doesn't seem overly impressed with the agency referring to Boko Haram as a, quote, insurgent group, end quote, given the terrorist designation, and given among other things that the group, quote, has caused more than 40,000 deaths in Nigeria, end quote, since 2009. To the court, the BIA can't simply hold, as it did here, quote, that a government's inability to protect its citizens does not amount to acquiescence, end quote, even when supported by some additional analysis by the agency. The IJ and the BIA must apply the First Circuit's two-step process in the First Circuit. Quote, specifically, the BIA did not identify the legal duty that the Nigerian government owed to Mr. Akinsanya, end quote. Y'all paying attention in the First Circuit right now? Unlike possibly in the Fifth Circuit, explains the court, quote, a non-acquiescence finding cannot rest solely on the fact that the government has taken some responsive action to combat private violence, end quote. Flat out, Immigration Court and BIA attorney advisors, you better cite and analyze the First Circuit's decisions in HH v. Garland, Mario Moracho v. Garland, and Khalil v. Garland. The court says as much in so many words multiple times. Episodes 130, 174, and 205, if you need a refresher. Quote, a no acquiescence finding cannot rest solely on the fact that the government has taken some responsive action to combat private violence, end quote. Quotes for days, this one. The duty to intervene placed on state governments by general principles of international law to protect its citizens is a powerful one, end quote. Sometimes, despite having taken some action, a government may still have a legal responsibility to do more, end quote. Is the fact that the Nigerian government is actively combating numerous terrorist groups and rebels sufficient to establish a likelihood that Nigerian officials would satisfy their legal duty to intervene here, in this particular case? And what is the specific legal duty to protect a former law enforcement officer by the Nigerian government? All questions the First Circuit needs answered. General government efforts to address violence are relevant, but not always dispositive to this inquiry, explains the court. All of this, despite the fact that it appears that the IJ did indeed correctly state the First Circuit's two-pronged acquiescence standard. It was the BIA that appears to have messed up the standard a bit on its de novo appeal review. But on the other hand, the First Circuit doesn't see the IJ as having provided a sufficient analysis. Quote, merely stating the proper standard does not discharge the obligation to correctly apply the standard, end quote. The First Circuit notes, for example, how very important certified expert testimony wasn't even discussed. So remand in a big way. All of this means congratulations to somewhat podcast regular Benjamin Asario, along with Elena Taylor of his firm. And of course, Sang-Yup Kim and Jao Bissonnette of the ACLU New Hampshire on amicus, because somehow, literally no First Circuit non-citizen win gets through in the First Circuit without ACLU New Hampshire somehow touching it. At least with asylum stuff. Dare I say a model for the rest of the country and the other 10 circuits for immigration cases? My final thoughts for the episode. If some of this seems a little academic to you, you're not alone. Naturally, right? Because I'm projecting. Not Mr. Akinsanya's fault. He asked the First Circuit to expressly further, quote, define what constitutes a public official's legal duty to intervene. Specifically, he requests that this court direct the BIA to apply a due diligence standard borrowed from the United Nations Committee Against Torture's General Comment Number 2, end quote. Full citation in the footnote in this decision. The First Circuit didn't go that far, but certainly didn't rule it out as the standard, leaving it to the BIA here to define the legal duty to intervene. But I mean, why not tether it to the UN's definition? CAT, after all, is a United Nations treaty. Massive things continue to happen in the First Circuit on CAT protection. And that is Akinsanya v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to, from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.